Hi, I'm Karen Roberts, solicitor and partner here at Ridley and Hall Solicitors. I have over 25 years experience. I'm based at our Barnsley office in South Yorkshire, and I have with me my colleague, a newly qualified solicitor, Chloe Flynn. We're both here to talk to you today about domestic abuse and the legal remedies that might be available to you. First of all, I'll address the definition. In the past, there was no legal definition of domestic abuse, but that changed in 2021, and Chloe will tell you a little bit more about the definition.
Yeah, so it has changed. There's now a legal definition contained under the Domestic Abuse Act 2021. So that act states that you must be over 16 years of age, you must have suffered abuse. And abuse is defined as coercive controlling behaviour, threatening behaviour. It can be physical, emotional, financial, and also other forms of abuse. And you must also be personally connected to your abuser.
So what is a personal connection for the purposes of the domestic abuse remedies?
So this is also contained under statute. To be personally connected, it basically means to be in some sort of relationship with the abuser. So there are examples, and there's quite a long list contained under the statute. Examples include being a relative. So for example, your abuser could be your mum or your dad. Also, another example is your abuser could be someone that you're in an intimate relationship with, cohabiting with, or it could be your husband or your wife. There are other examples, but like I say, the list is very long and it is contained under statute.
And so if you've experienced domestic abuse as defined by the Act, and you're a person who's connected as defined by the Act, you can apply for a non-molestation order. A non-molestation order is an order that prohibits the abuser from using or threatening violence, intimidating, harassing or pestering the victim. It prevents contact, direct or indirect, and it can prohibit certain communications such as telephone, text or by social media. It can also include an exclusion zone or prohibit the abuser from coming onto a certain street, such as the street where the victim lives. It is actionable by the police if there is a breach. So in terms of the process for a non-molestation order, Chloe, perhaps you could explain that to us.
Yeah, so for a non-molestation order, you'd make the application to the court on the court form. You would accompany this back with a statement. So the statement would set out the incidents that have occurred and why a non-molestation order is necessary. This can be done in two ways. So you can make an application to the court on notice, or you can make an application to the court without notice. And maybe Karen can explain the differences between the two.
Yes. So without notice is ordinarily made where there's a significant risk and an immediate risk of abuse, and perhaps where the victim is fearful that they might be dissuaded from making the application and seeking the remedies from the court. It's an application where the abuser doesn't know an approach has been made to the court, the application's been lodged. You're asking the judge to put the order in place in secret, and so that as soon as the order is personally served on the abuser, it's fully enforceable. With a without notice process, there is then a second hearing where the abuser has the opportunity to be heard and to comment on the application. The on-notice application isn't made in secret, it's made in full knowledge of the abuser. The application is issued by the court and then sent out to the abuser with a hearing date. There's usually one hearing where everybody attends to answer that application and make representations as to the judge as to whether or not that order should be made.
Yeah, so I think we've briefly touched upon the point that a non-molestation order is an arrestable offence. There is an automatic power of arrest attached to it, which means that if the abuser does breach the non-molestation order, the police can intervene, and you can also bring it back to the court for being in contempt of court. I think the final thing to mention, Karen, is the occupation order as another form of protection for victims.
Yes, an occupation order can be made by the court. The purpose of such an order would be to require the abuser to leave the property or to stay away from the property. It's made where the abuser has perhaps a contractual right to be in that property because of, say, a tenancy, or they're entitled to occupy that property because it's a marital home. So the order, once made, would require an individual to leave and stay away, and these orders can be time limited. I need to comment in relation to occupation orders. They're rarely made on a without notice basis. They're rarely made by the court in secret, because that's a very serious and old-fashioned remedy to make to exclude somebody from effectively their home without them even knowing about it. So you can apply on a without notice basis, but if you did so, then the court would deal with the application for the occupation order at the second hearing, at the hearing where the abusers had notice of the application. So perhaps Chloe could mention how available it is and whether there's how to fund such an application.
Yeah, so legal aid is available for victims of domestic abuse. You must meet the income and capital thresholds. These are on the Legal Aid Agency website under the gov.uk, so you can actually check them. There's no need to prove that you've been a victim of domestic abuse. It's just whether you fall under the thresholds for income and capital needs. So yeah, if you are worried and you do want some support, then please do get in touch with a solicitor. At Ridley and Hall we can help. Our family team have a lot of experienced solicitors that have dealt with applying for non-molestation orders and occupation orders in the past, and it's always wise to speak to a solicitor regarding this point.
Yes, and we can generally determine how quickly we need to respond to that application, and we would generally also have availability to meet the needs of somebody that really does deserve us to take quick action. So I hope that's been helpful. We've enjoyed this question and answer session, and we hope that to assist you if you need our help in the future.
Thank you.
Thank you.